This is how it went.
Like, come home. Please come home. I miss you. The kids miss you. I don't know what's going on lately. This little sojourn of yours. I understand you want to see the world. I understand you want to do things outside of, all the other things that you do, but we need you.
He does. He really does. Seriously, he's been at my house crying nonstop. Please come back. I can't kiss him anymore. I can't pretend to be you anymore. I just can't. I'm trying, but it's just so...
His basement is so scary.
It is.
And I
Please come.
don't have anyone to hold me.
Well, friends, here we are. We're finally at a point where the Wayfair parties are getting ready to file an appeal, and everything just changed. Let's talk about it. So on Friday, the New York Times filed this motion. They're asking the court to finalize their judgment, declare them the winner. And by doing so, they've asked the court to start the clock so that Wayfair can file an appeal against them. In response to that motion, Wayfair has now hired one of the leading appellate attorneys in the country, Alexandra Shapiro. And this new firm appears to be in place as Wayfair parties prepare to appeal Judge Louis Lyman's dismissal of the New York Times, Blake Lively, Ryan Reynolds, and Leslie Sloan. So on Friday, in a motion, the New York Times were seeking an entry of judgment under Rule 54.54B. What this ruling does is it allows the court to close the case against the New York Times on a very active docket that continues to post updates on the daily, with over 700, close to 800 docket entries. The New York Times was dismissed from the case in June, but because the case with Lively continues to be ongoing, the case is not over, and Wayfair cannot appeal the decision of the dismissal against Lively, Reynolds, Sloan, or the New York Times. And now the New York Times wants out because they want to allow Mr. Baldoni and Wayfair the opportunity to appeal if they're going to, and they've even cited a few areas in which they believe they might be vulnerable to appeal. In their letter, it says, because this case remains active and because final judgment is generally only entered after the rights and liabilities of all parties to the action have been adjudicated, the court has not yet entered judgment in favor of the Times against the Wayfair parties. Under Federal Rule of Civil Procedure 54B, a court can enter judgment in an action involving multiple parties when the claims against one party have been finally decided and there is no just reason for delay. They are a third-party news organization. They are situated from all of the other remaining defendants. The claims against the Times have all been dismissed with no further leave to amend, and entering a judgment would expedite resolution of the case between the parties and the Times by the Wayfair parties, allowing them the immediate right to appeal and ensuring a prompt resolution of this case, aligning with the New York court's direction that defamation actions should be dismissed at the earliest possible stage due to the real risk of infringement on First Amendment rights. They say that this decision will not affect the rights of the remaining defendants, and they want the court to enter a judgment in favor of the Times against Wayfair. What I find really interesting about this is that they have really changed their position. They were so adamant that their story was about sexual harassment that occurred on the set and this sinister campaign that was undertaken by Baldoni to ruin the reputation of Blake Lively. They were adamant that it was about sexual harassment and it wasn't about creative differences. But now they're framing it as though they're admitting, oh, no, there was creative differences, which underscores Blake's point that creative differences had nothing to do with it. They write, as the article reported, the filming, production, and post-production of the movie were plagued with controversy about the movie's contents, intimacy scenes, and its marketing, among other things. The article explained that Lively had alleged that Baldoni and others engaged in inappropriate on-set behavior, and then, when they feared that her allegations would be made public, they created a smear campaign to tarnish her reputation. But in the very beginning, this is what they say. The actors vehemently disagreed about creative control of the movie. If creative control is not a factor in this case, then it shouldn't be an issue addressed by New York Times, right? They believe now that it was about creative differences. So it seems like a pivot a little bit. They admit that the article explicitly relied on and cited the CRD complaint as well as text messages, emails, and other documents included. So here they're admitting they went outside of the CRD to form their reporting. They note to the judge that there are actual grounds here that if the Wayfair parties wanted to appeal, they could. So they tell the judge that in determining whether the Wayfair parties adequately pled a defamation or false light claim against the Time, an appellate court would be required to determine whether the statements in the article were privileged as fair report of the CRD complaint and whether those responsible for the article's publication acted with actual malice, subjective knowledge that the article's contents were false, or a high degree of awareness of probable falsity. These questions are entirely unique to the Times. The fair report defense requires comparing the published article to the filed CRD complaint. The actual malice is a subjective state of mind that must be pled and proven as to each defendant. Thus, the conduct of other defendants and the fact that the Wayfair parties also brought defamation claims against those defendants have no bearing on appellate court's review of the defamation and false light claims against the Times. So really what they're saying is that there is a dispute here about whether or not the CRD report that wasn't a court record qualifies under fair report, right? So there is a privilege that's afforded to journalists called the fair report privilege. And it allows journalists to report on matters of the government and government documents that are filed before a court within a governmental institution if they are public records. So it could be an official proceeding like a case, a lawsuit. It could be governmental documents, statements of public officials that are accessible to the public. It could also be matters of public concern reported but must be of public interest. And in this case, there will be a dispute about whether or not this was actually a public record, along with was it portrayed accurately as a CRD complaint rather than a lawsuit. And one of the arguments that Wayfair has made consistently is that the California's Civil Rights Department and this organization where you file this document, these are not automatically public records. So when you file a CRD complaint, whether it's for discrimination, harassment, or retaliation, the complaint itself is considered confidential during the agency's investigation, and it's not something the general public can freely look up like a court case. The respondent is the employer and landlord or entity that's being accused. They receive a copy of the complaint once it's accepted, so they know what the allegations are. Full complaints are not published online, and they don't release aggregate data and may disclose limited information in response to a Public Records Act request. So if you were to go to the CRD and request a copy of this complaint that she filed,